נתתי לסידור. נתתי לסידור 3 סטים. אתה רוצה העתק with compliments? לא, צרפתי. דווקא כן. זה לא שלי.
I wish to announce the order of the coming sessions. At the request of the two sides, the following arrangements were agreed. This afternoon there will be no session. The Attorney General will complete his summing up in tomorrow's first session, tomorrow morning. Then there will be a break until Monday. And the Counsel for Defense will probably begin and end his summary pleading on Monday. As we have been told, it may take only the morning session on Monday. Mr. Hausner, please proceed now.
Now, honorable judges, to the famous transaction of blood against goods.
negotiations for the saving of Jewish lives against the payment of monies and the handing over of property to the SS were conducted in many ways. The Kastner report speaks about this at length, and in the written summing up, the court will find quotations in regard to the development of these transactions. Freudiger testified in court about the valise full of money and jewelry handed to the Germans. This was confirmed by Krumai when interrogated in Germany. At a certain stage, Himmler realized of his own initiative or on the advice given to him by others the possibility of exploiting this negotiation for private purposes and political purposes, especially that this will enable him to contact the Western allies. This is also the testimony of Kaltenbrunner, and there is no reason to doubt the trustworthiness of these words because this was not in self-defense. And he added, from this moment onwards, Himmler lost grace completely in the eyes of Himmler, because this act did a lot of damage to the Reich abroad. This was also remarked upon by Schellenberg, and this evidence corroborates the version given by Becher immediately after the war. The research carried on at Nuremberg, and then the testimony given by him in this case in Bremen. Becher does not hide the fact that the directions received from Himmler was, promise the Jews what you wish. What we keep is a different matter. That the transaction was first and foremost intended for the political aims of Himmler. Therefore, as is known to us from the Kastner report, Becher saw and regarded this as an important achievement for meeting McClellan, Roosevelt's representative. Therefore, Becher tried to praise Himmler, describe him before Kastner as a trustworthy person and almost as a defender of the Jews against Kaltenbrunner's conspiracies. Therefore, the matter of the transaction was kept secret from the foreign ministry of the German government. Ribbentrop asked angrily the embassy in Budapest, what is this all about, when he learned about the matter from the London Broadcasting Service. 2 months after Brandt was on his way, and then Wesenmeyer answered, embarrassed, trying to find excuses, and relied on Winkelmann and on Grell. The German Foreign Ministry did not know about the transport to Bergen-Belsen, and special notes drawn up for Ribbentrop. This was explained as being an assignment from Himmler to Eichmann. Eichmann was instructed to conduct these negotiations, and this to give it his own personal experience suitable in the dealing with Jews. But he was not told about the top state secret of the transaction, which seemed to him strange and was forced by the order given from above. When questioned by the police, this is what he said. The order was given by Himmler. From whom the idea emanated, Becher or Himmler, or from myself, or that it crystallized in some other way, this I do not know. At the same interrogation by the police, he said that he cannot remember a conversation with Brandt, that he has no standing point in regard to the whole episode, and that as far as he was concerned, he cannot be responsible for this matter. And this is what he said to Zassen In the quotation read into the record at session 103, page 17, such a matter of 10,000 trucks I would not have brought into account at all. I would not have dared to consider such a transaction. It would never have come to my mind. And here, by the way, I wish to add that in contradiction to his argument that the Zassen reports came to make the book interesting and to make it a bestseller, this quotation testifies to the contrary, and these sound to be true words, as well as the lie in his reasoning is glaring from other quotations. It is possible that Eichmann is angry with Becher because he interfered in Jewish matters. He was always angry when anybody tried to interfere in such matters or tried to take them out of his hands, as happened in Holland, when someone from the local authorities tried to intervene and decide in Jewish affairs. He called this in public a folly, as he admitted at the cross-examination. Maybe he was also furious with Becher, who trespassed innocently. But this fury did not rise from any other reason but from his wish and will to be the only and single executor in matters of Jews, at least in the stages of implementation. Hansi Brandt testified here in court. With a clear conscience, I can say that as far as the transaction is concerned, he was satisfied that it did not come through. Wislitzeni related the joy Eichmann expressed when Brandt did not return. And since this happened, Eichmann refused to receive Kastner for further conversations and planned to have him liquidated. Eichmann expected the deal to fall through, and he was ready to contribute to the failure of this transaction without openly showing that he was flunking Himmler's orders. And in order to complete the whole matter, he started the deportations at an accelerated speed. And from the day Brandt left on his way, daily 12,000 men were sent to Auschwitz. And his attitude to the whole chapter he revealed to Zassen in a quotation which is before the court. My heart was never with the opponent. I prefer a dead opponent than a live one. But when I have orders from the Reichsführer to mechanize the 22nd and the 8th Division by 10,000 vehicles, trucks, then let 1 million Jews go to hell. My heart I never asked. I had to ask Germany. In times of emergency, we would have given them 2 million in exchange for 10,000 trucks, because then I would have extracted from this transaction whatever possible. This once again is proof that not all Jews were thrown into the furnaces. They were still there, the Jews. This is the end of the quotation. Eichmann to Zassen. When questioned, he said that he believes his words were corrected slightly. They were retouched, as he said. But these are the precise words describing his attitude, his true attitude to the transaction. his wish to have this transaction fail, as transpires from the report, the Kastner report, from Hansi Brandt's testimony, from that of Becher and Wislitzeny. Did we not hear similar words when Brack of Hitler's chancellery requested a number of trains which he obtained at great trouble only because Brack wants them and wants to throw more idiots into the furnace? This is his style and language. And these are the traces spread all over the manuscript, the Sassen documents. The curses, the crude expressions, and all other ways of expression. The people who are thrown into the furnace are fuel for those furnaces. The dead Jew is always preferable to the live Jew. But when there is an order to leave the Jew alive, and thus two divisions can be equipped to SS divisions, and the time is a time of emergency, then the position is different. This was what Adolf Eichmann said. But all this performance we heard here, that he as Brandt is full of sorrow that the transaction failed. This is duplicity, for which we cannot find a suitable description. And in truth, why should he show any human feelings towards his Jewish opponent when even his own enemies of his own people he was ready to liquidate? He admitted that much on cross-examination, that he proposed to Miller to put up against the wall 100,000 Germans for lack of loyalty to the Führer, and said that only after their own stable is cleaned they will be able to introduce order into other camps. And when I read it to him, the number mentioned was 500,000 Germans, not 100,000. These pearls of speech in Hungary are known from the Kastner report and other evidence. I must purge the provinces from the Jewish manure, he said to Kastner. And if no reply is received within 48 hours, I shall order to throw all this heap of Jewish manure to Budapest. And what did Friedman say about Eichmann's visit to Majdanek when he looked at the prisoners and said, "Remove this heap of manure"? This is Eichmann's language. He added to plan the arrest and the deportation of Jews from Budapest, even after Horthy stopped the deportations, and he made all preparations for the deportations. The report sent to Ribbentrop carries his handwriting, Wagner, that Eichmann came to an arrangement with Wesenmayer and arranged all the details regarding a surprise action against all Jews in the city. And in cross-examination, he admitted that much. The official correspondence reveals the bloody conspiracy against the Jews in Budapest and his plans against the surviving Jews. Plans for camouflage, and then it seems that it was decided to carry out the plan without camouflage. This these were not satisfactory. The ministers, the Hungarian cabinet, decided on the 13th of August 44 that this surprise action will take place on the 25th of the same month. Eichmann did not agree. He demanded of the Minister for the Interior, the Hungarian minister, to fix an earlier date, the 20th of the month. The Hungarian claimed that this was demand new arrangements, and then they reverted to the first arrangement of the 25th of the month. The Jews who learnt about it somehow continued to beg and try and intervene in all directions, as transpires from Kastner's report. All of a sudden, Himmler ordered to stop deportations. On the same day, after receiving Himmler's order, Becher cabled to Himmler this request. Eichmann did not give in even in face of this Himmler's order, and requested Winkelmann, Himmler's representative in Budapest, to keep Himmler's order secret, to know whether the consent, Horthy's consent for the deportation of Jews from Budapest was received in the meantime. But Wislicenny learned about the contents of Himmler's direction, and he told Kastner about it in the words appearing in the Kastner report. You won. Eichmann is leaving. And the Jewish leaders also informed Horthy about Himmler's order, and he became brave and once again forbade the arrest and the rounding up. Then the thing did call Eichmann and put him in a fury that he proposed to remove himself and his unit from Hungary. The Germans still continued to talk the Hungarians into carrying out this at the end of August, the deportations and the expulsions, but this did not come about. What caused the retreat of the Hungarians? This must have been the pressure on the front, the fear of adding a sin to a crime, and the intervention of many, many circles with Horthy. And what made Himmler keep back the deportations? This is difficult to say, and he must have taken the secret with him to the grave. Maybe this hesitation of Yoel Brand on his way, on his mission in regard to the transaction, this brought it about. Or maybe the very fact that he never came back from this mission, empty-handed. All kinds of thoughts come to the mind. But it seems that in the meantime the Germans believed that the Jews already had 250 trucks, as we learned from Freudiger's testimony. Kastner kept on pressing to stop deportations, that this interferes with the transaction. Grell, the advisor to the embassy, informed Wesenmeyer that in spite of the BBC informing that the Allies will not agree to the transaction, there is hope that this will come through. Because the broadcast is a camouflage to cover up the negotiations. And Rudolf Hess testifies clearly and explicitly that when all of a sudden deportations to Auschwitz stopped, he wanted to know what was happening and proceeded to Berlin. He was referred to Eichmann at Budapest, because in Berlin there was no one to give him the full information. In Budapest it became clear to him that the negotiation in regard to the transaction, this is which caused the cessation of deportations, because Jewish functionaries demanded to cease extermination as a sign and token that the German proposition was serious and sincere. And later, after this short break and interval in deportations, Eichmann came back to Hungary once again on the 17th of October and told Kastner. This is what the report says. You see, I am back. You hoped in vain that the case of Romania or Bulgaria will be repeated here. The Jews of Budapest will be evacuated. The means of transport are necessary for other purposes. Therefore, they will be removed from Hungary in another way. And the horrors of the foot march are known. Eichmann's responsibility, transparent, are evident from all documents. It is not necessary to repeat. The details will be found in the report, and they are also included in the written part of the summing up. It was known that he was the man to organize this mass murder. It was a known fact to the deportees themselves, as we heard from Mrs. Fleischmann. And she told the court, she related the horrors, the atrocities, about the pigsties where the deportees had to live. The corpses with a yellow patch on their back, on the sideways. And when the blood was still streaming, the furnaces where they took refuge, the young and the old who marched, the pregnant women during their last months of pregnancy who were taken on this march. And one of them later in camp, when she was lying in labor, the Lagerführer stood across the room with a torchlight. She was lying on the floor, and he was standing there with his hands on his hips, saying, I want to watch how a human being is born. And the deportees became weaker from day to day. Disease spread amongst the deportees. The meningitis, the inflammation of the brain, claimed many victims. Hundreds and thousands fell on the way. Court will find the details in Fleischmann's testimony. Eichmann watched the march. He admits this. He saw only 2 dead. But if he saw the march, and he saw the atrocities, the thousands treading in the mud, those dying on the sideways, falling with fatigue, and those shot at by the guards. These were only Jews. There is nothing to be excited about. We heard from his own mouth that this never brought excitement to his heart. This was the end of his action in Hungary. This he described years later to Zassen in the following words. He admitted the truth of this quotation. The Allies bombed the railway stations and the tracks. Then I wanted to show them my mighty arm, Nothing will help you. We shall march. And then came his own words in his own handwriting. He proposed this march. And then he writhed when cross-examined, saying that he only negotiated in regard to food and storehouses for the marchers. Then he retreated, saying that in fact he proposed a different kind of march, not the one which actually took place. And the great lie burst once again when Eichmann speaks of Eichmann in a different quotation in Sassen's document, that after the march was carried out, he was congratulated by Andre and Bucky, and once again they drank to celebrate the event. This time we know that they had mare's milk brandy to drink. This is how the chapter about Hungary was concluded. These were his last contacts with death. I must add a few words in regard to the chapter of the murder in the cherry orchard. We did not accuse him over the murder of the boy in the indictment, and we did not bring the whole chapter, but to prove his attitude and approach to the life of a Jew. Abraham Gordon, who testified in connection with this matter at the 57th session, described the work at the Ashner Villa. He related about Slavic, about the storeroom for tools, the shed, about Slavic's personality, who always said, "Beware of me." He described the beating up of the boy Solomon, who said that he was removed dead, the amphibious vehicle. He related about Title, who said, "I threw this corpse into the Danube," and told the other boys, "This will be your fate as well." He added and related that he never saw Solomon again. He described the disappearance of Kolbach and the slaps he received from Eichmann. And this tale, this matter of the attempt to assault a girl. The counsel for the defense questioned Gordon in cross-examination, and Eichmann tries to wash his hands of the whole matter. Gordon, in his story, there were two contradictions. Whilst once he said that he told his brother about the whole matter an hour later, he said somewhere else that he told his brother a year later. And whilst once he said that the beating were carried out with a belt, in another place he said that this was done with a heavy instrument. Your Honors, these contradictions are not serious. The counsel for the defense could call the brother to the witness stand and find out when he learned about this incident. Gordon told us about the testimony at the police station in Eilat, and there were difficulties with the policeman who took this evidence, and maybe the year and the hour were mixed up. Gordon made a good impression. He gave his statement to the police on the 15th of June, 60. The number is N1, very near to the time when Eichmann was caught. And of course, before he could have known what Eichmann has to say about the matter, and before he had any possibility or chance to invent tales. He knew details which Eichmann on one hand and Slavik on the second hand do confirm them, as well as Krumai. Villa Ashner, this is correct. He knows the names of Slavik, Title and Kolbach. He knows about the amphibious vehicle. He knows about the work carried out by Jews in the garden. And he knew about the existence of an orchard. So what actually happened? According to Eichmann, this is a story invented from the beginning to the end. But whose story is really the invention? Eichmann testified in court after seeing Krumai's evidence and before he saw Slavik's testimony. So that when Krumai mentions Slavik in his testimony, he also nods and says Slavik was there as well. But since Krumai does not mention Title, he as well cannot recall Title. And when he is questioned whether Slavik was the man to supervise the works, he says, yes, this is quite possible. It may have been that he was in charge, but he does not know that Slavik in the meantime testified and described who Title was, and that Title was in the meantime executed for robbery. Slavik knew about the engineer Kolbach. Eichmann never heard the name before.
We should like to ask the court to give credence to what Gordon says, not because we want incrimination in connection with the murder of the Solomon boy. We did not put this as an item in the indictment. We had no intention to single out this boy from the millions that had been killed. We simply want to shed light on the brutal attitude to a Jewish boy whose act of stealing cherries was enough for Eichmann to be an accomplice, at least, in beating this boy to death. This is his general attitude to Jews, which is clearly brought out here, and this is also is a flagrant contradiction to what he says, that this delicate man was not at all capable of raising his hand on anyone at all.
Judge Halevi, I have one question. In regard to the contradiction between a year and an hour, the counsel for the defense could have called upon the brother of the witness. Was this not the duty of the prosecution?
We didn't think that this contradiction is fatal in any way or importance, and we thought that Gordon had given a reasonable explanation for this particular contradiction, and we are not obliged to give more explanations thereon. The witness testified, the brother is available, the counsel knew it and could have invited him. If there were a particular count we had indicted him on, then of course we would have to call the witness, but this was not the case.
Judge Halevi, don't you think that the onus of proof in regard to this special charge is easier than in the case of murder? The onus which is upon the prosecution.
When we ask the court to take evidence, then of course the onus of proof lies on us all throughout the problem. Then of course we have to bring witnesses. But we believe that there is a difference between the quantity of proof required for prosecution in order to accuse and between a certain argument which only testifies to a certain feeling, brutality and hatred of Jews. And when this is fitted into the general picture, into the general framework, I believe that as part of all the chain of proof, then our obligation here is less weighty, and as I said before, with regard to the fact that the name of Eichmann was well known in the ghettos of Europe, and the judge asked me what value has it got at all, and I have to say that this alone, this by itself has no value from the criminal point of view, because there is no proof thereto. But the fact that this name has been heard in the ghettos and no other name is most significant. Therefore, in other words, we can't conclude from Davinsky's evidence and other such evidences that Eichmann is indeed responsible for the execution of all the anti-Jewish operations, but we could determine the fact that they had heard about it, and this sheds light on the problem. So why not? Why haven't they heard another name? And now I'm going to the core of the legal matter involved. The problem of orders from above, so to speak. Eichmann's defense in saying that he had carried out orders from above is not a defense in this trial. Already paragraph 8 for the punishment of Nazis and their collaborators in 1950 prevents the application of another paragraph, and the other paragraph might give reserve defense to those who carry out orders. In other words, if it hadn't been for the paragraph 19, the order couldn't have in any way constituted a justification for an act which otherwise would have to be considered illegal. And the legislator then took away from the accused, in accordance with the law for the Nazis and their collaborators, took away the possibility for them to avail themselves of that particular article number 19. This was done in the wake of what had been proved against the Nazis, and also on the basis of London Charter and on the basis of long experience with war criminals. The paragraph number 8 of the Charter is here to be applied. We haven't introduced any innovation into this legislation which has already been enshrined in other charters and codes. And even if Article number 19 could have been applied, and even if the accused had not been expressly deprived of this way of defense, this would have been of no avail, and for certain reasons. First of all, this must be a legal order which is being carried out in order to constitute a defense. For instance, a soldier shooting at the enemy in the battlefield will certainly not be amenable to justice for what he's doing. But a soldier who continues shooting at the enemy after the enemy had laid down arms would be accused of murder. And those who carry out illegal orders can certainly be brought to book according to law. The military district court at the Kfar Qasim case had given the following definition in its judgment. In the penultimate paragraph, I can't do it.
When this was like a black flag flying above the order, not a formal illegality, not an illegality which is discovered only later, but the breaking of a clear law, a clear illegality appearing in the order itself, or the actions ordered by this order, if the eye is not blind and the heart is not cruel and corrupt, then this is the extent of such manifest unlawfulness as is necessary to release the soldier from the duty of obedience imposed upon him and make him criminally responsible for his acts. And the Supreme Military Court, when dealing with the same matter, adopted the same words, and in paragraph 67 of the sentence, on page 32 and 33 of the legal matter of our pamphlet, after quoting the part I just read. And after the quotation was defined as expressing the idea in the befitting words, in other words, the fact lies that this time the general principle is abundant, and that not knowing the law is no excuse to an omission or a commission which would have constituted a crime otherwise. And because of the special circumstances a man is found in, the legislator will not call him to justice for ignorance of the law, but this ignorance of the law does not afford any excuse for any commission or omission which would otherwise constitute an offense. That a sincere and reasonable mistake of fact does absolve one of criminal responsibility. About the reason which lies in the disobedience to an illegal order, we read Stephen about the criminal law, and this on page 21 of the pamphlet.
The doctrine that a soldier is bound, under all circumstances, whatever, to obey his superior officer would be fatal to military discipline itself, for it would justify the private in shooting the colonel by the orders of the captain, or in deserting to the enemy on the field of battle on the order of his immediate superior. I think it is not less monstrous to suppose that superior orders would justify a soldier in the massacre of unoffending civilians in times of peace, or in the exercise of inhuman cruelties, such as the slaughter of women and children during a rebellion. The only line that presents itself to my mind is that a soldier should be protected by orders for which he might reasonably believe his officer to have good grounds. דברים אלה נכתבו שנים רבות שיכול היה לחזות בעיני רוחו
years before one could imagine the great holocaust which was about to take place, and this in accordance with orders from above. But this holds good also in connection with the man who implemented this terrible atrocity. It is therefore impossible that the military court at Nuremberg, which was demanded to lay down the law in this matter, said, and this is on page 33 and 34 of the legal material.
It was also submitted on behalf of most of these defendants that in doing what they did, they were acting under the orders of Hitler, and therefore cannot be held responsible for the acts committed by them in carrying out these orders. The Charter specifically provides in Article 8, the Niskara Charter. The provisions of this article are in conformity with the law of all nations. That a soldier was ordered to kill or torture in violation of the international law of war has never been recognized as a defense to such acts of brutality. Though, as the Charter here provides, the order may be urged in mitigation of punishment. True test, which is found in varying degrees in the criminal law of most nations, is not the existence of the order, but whether moral choice was in fact possible.
What is actually the meaning of these last words, but whether moral choice was in fact possible? Mr. Hausner, the problem is not, as the court says, the military court, whether such an order existed or not. The question was if there was a possibility to think and decide for himself to obey the order or not to obey the order. In other words, if there was any possibility of reasoning of the man who was ordered to carry it out, could he think whether the black mast is flying or is it not there? Judge Halevi, maybe this is in a case of duress, whether there was any possibility at all of not carrying out the order. Mr. Hausner? Your Honor, then the criterion is not moral but physical. If someone draws a revolver and says, kill your comrade, otherwise I kill you, this is not a matter of choice, but this is a matter of a lack of choice. But I believe that the words hint at the possibility that if a man is given an illegal order, if he has at all the physical possibility of weighing at the moment, on the spur of the moment, if the thing demanded of me to do is legal or illegal, and if the man is given the opportunity to reason with himself, as the accused said, ich habe mitgedacht, I did think, then he did have the possibility and the choice not to obey these orders.
Right.